A lot of technical language, legal language from Lord Reed there on Supreme Court, but I'll try and break down for you exactly what he said. So the top line, the headline of all of this, is that he's effectively found that the Court of Appeal's ruling on many grounds was incorrect. And so largely this is a win for the banks. Lord Reed looked at a few key details, Supreme Court judges looked at a few key details on whether this amounted to bribery, on whether the dealers owed the customers a fiduciary duty, effectively loyalty, should they have been acting in their interest. And it's interesting that the way Lord Reed set this up, he spoke about the relationship that these dealers have with the banks, as well as with the customers, this sort of three-way system of advancing car loans. And he effectively said that no, they do not owe that loyalty to the customers. The Court of Appeal said that they did, but the Supreme Court judges said that that's not true. And as a result of that, these commissions don't amount to bribery. He actually said that it was quite clear that they were motivated throughout to sell cars at a profit. And that should have been clear to everyone that that was effectively what they were trying to achieve. So that duty was not owed to customers. And what does this mean? Well, most banking experts, most lawyers had expected that the Supreme Court would overturn that judgment, at least partially that judgment by the Court of Appeal. That has happened. So this isn't going to come as a massive surprise to the financial markets. It's not going to come as a huge shock. And actually, it's interesting and worth pointing out that Lord Reed in his opening remarks said that they had decided to make this announcement, make this judgment after trading hours so that the market could have some time to digest the news, to avoid disorder in the financial markets. And that just kind of signifies just how significant this could have been if the Supreme Court had found alongside the Court of Appeal, if it had upheld the Court of Appeal's judgment, this could have been potentially massive and damaging for the banks. In the end, it didn't, but it did point out one notable exception. So I was looking at three test cases, three consumers who had been affected by this. And in one case, the case of someone called Mr. Johnson, it said that the appeal could be upheld based on the Consumer Credit Act. There was an important exemption in there. I've actually got Damon Parker, a lawyer who specialises in these cases. He was trying to make sense of all of it with me. Damon, can you talk me through that exception?
Yeah, there's a provision in the Consumer Credit Act that says that where the relationship between borrower and lender is unfair, then it's possible to be compensated. And the case of Johnson was actually quite extreme. He was a young man, 27 years old, buying his first car. The dealer was selling it to him for more than £1,500 its true value. The lender wouldn't lend more than the Glasses guide price. The dealer got him to take out a further personal loan, effectively to pay his commission. And so you can see that the whole circumstances in which he bought his car were just a bit odd. There are 3 points that the Supreme Court pointed out that were unfair here. The two main ones were the size of the commission, which was 55% of the credit. Huge commission. And secondly, the documents were just very misleading. They didn't give him any sense at all of what was going on. And so you can see why, in those circumstances, the lending relationship was unfair, and so compensation was due.
So that was a particularly egregious example that broke other types of rules and regulations.
Absolutely, and the Supreme Court has been quite careful to say that you've got to judge these cases on their own facts, and so it's not a sort of blanket suggestion that anybody can go to court to get an unfair relationship judgment in relation to their motor financing. It's specifically not saying that.
But the banks aren't completely off the hook here, are they? Because they're still set to pay billions of pounds in compensation over commissions.
That's absolutely right. They'll be heaving a big sigh of relief that they're not on the hook for fixed commissions. But it's still very likely that there will be a consumer redress scheme in respect of discretionary commissions, which we were talking about earlier. And they're the kinds of commissions where the lender motivates the dealer to act against the interests of its customers by giving them a license to increase the rate of interest. And the higher the interest rate paid, the higher the commission. Obviously unfair, and actually outlawed by the FCA back in 2021.
Thank you so much. Damon. So Damon there was talking about discretionary commissions. That was a practice that was outlawed in 2021. But before 2021, as he was saying, it was widespread for dealers to be paid these commissions based on how high an interest rate they could get for their lenders. And that was outlawed, that was banned by the FCA, but they're still going to have to pay billions of pounds in compensation. Could be in the region of about 20 billion pounds, but they'll be breathing a sigh of relief that it's not bigger, that it's not much larger, in the region of 44 billion pounds. And actually the government will also be breathing a sigh of relief today, because the fear was among the banks and the government that if the Supreme Court today decided that the Court of Appeal was correct and they have upheld that appeal, then this could spread to other forms of lending as well. So not just in the car market, but for example, the way you buy your kitchen appliances, the way you buy your furniture, extended warranties, any type of lending where as part of that there is a commission structure in place. And if that happened, the fear was that it could be so expensive for the banks, it would limit their risk appetite, that it would make it more expensive for customers to borrow money to buy things like cars in the future, that some of the lenders, the smaller ones at least, may go bust. And that was actually the sentiment behind some reporting which suggested that the Treasury and the government was actually considering intervening to overrule the Supreme Court today through primary legislation. Now, that would have been hugely significant. It's not unprecedented, by the way. Stuff like that has happened in the past, but obviously it would be hugely controversial. It's not something that the government wanted to have to do, and it's probably pretty happy today that it doesn't have to.